The Federal High Court Abuja has admitted in evidence a testimony by a witness of the Department of State Services, DG Adinaju, in the ongoing trial of former Kaduna State Governor Nasir El-Rufai for allegedly wiretapping the telephone lines of the National Security Advisor, Malam Nuhu Ribadu. Mr. El-Rufai had, in a February interview, claimed to have been wiretapping the telephone conversations of the NSA. The witness and a human rights lawyer told the court that he appeared for an interview program on a national station on February the 16th, the same day that Mr. El-Rufai made the confession on the same television station. Now, the prosecution tendered the subpoena used to summon Mr. Adinaju, which was admitted and marked as Exhibit G. Now, the court also viewed the interview involving Mr. El-Rufai, after which Mr. Adinaju confirmed the recording and the statements allegedly made during the program. The prosecution subsequently tendered Mr. Adinaju's own interview contained in a flash drive alongside a certificate of compliance. Both were admitted in evidence as Exhibits H and H1. On the cross-examination by the defense counsel, Paul Erokoro, Mr. Adinaju stated that while he did not hear Mr. El-Rufai specifically say he hacked the phone lines of the NSA, he heard him say, quote, "We listened to the conversations of the NSA," end quote. Meanwhile, the prosecution tendered an official gazette without objection from the defense, and the document was admitted and marked as Exhibit I. Now, the matter was adjourned until June the 23rd for continuation of trial.
Before today, on the day the motion for recusal was moved, the court adjourned to Monday for the ruling. However, what happened was that Monday the court did not sit because the court was reshuffled and taken to the fourth floor from the third floor. And the reason was because the court said that because he has just been moved to a new court, he cannot sit on that Monday. And of course, they communicated a new date. However, the defendant had a medical appointment which the flight had already been booked. He wrote a letter informing the court that he cannot come on this day, which is the next day, because he has to attend other functions and suggested dates. However, on the day of the hearing, the court revoked his bail for not being in court despite the letter being in the court file, and the court even acknowledged this and went ahead to issue a bench warrant, which was not executed until today because there is an application that was filed by the new lead counsel, Leonard Silk, and the court is aware that there is a motion for him to stay the execution of executing that bench warrant, and also another motion to set it aside. But then in the court, in his wisdom today, decided to adjourn the matter to next tomorrow for hearing of those applications, and based on the fact that there's already a ruling that his bail be revoked and that it should be remanded in Kuje Correctional Center today. So we are surprised anyway because there's already a motion, and the motion has been brought to the court notice that this execution should be stayed. However, the court went ahead to remand the defendant, in the correctional center today, and that is the reason why you see a lot of people protesting in court, and a lot of comrades and those in solidarity, agitating that this is an injustice. However, on the merit of the case, we will not comment on that yet, but this is just the update on the face value of what has already happened in court.
So okay, what will be your charge to the justice?
Yeah, come again?
Your charge to injustice.
To injustice.
You claim that it was an injustice.
I didn't claim that it was an injustice. I just said that that is the position that the court has taken.
Okay, very quickly. Now that the bench warrant has been executed and the trial judge has refused to recuse himself, how confident are you in getting justice on this very case?
Well, this is a matter. This is a matter that is going to be left for appeal. Obviously, it's a constitutional right. A decision can be taken by a judge, and if you feel it's not in conformity with the law, that is the facts, and the law has not been properly applied, what do? You go on appeal. So yes, the matter is already ripe for appeal, and I can say that we are going to discuss with the legal team. We're going to discuss within the legal team and see the way forward from there.
Thank you. Your name once again?
Yeah, Wayne Chikeze, like that, Esquire. Thank you.